Hello everyone, it's a pleasure to be with you again. This video article is about climate change and the environmental mark of the United Nations Convention on the Law of the Sea. It is based on my lectures on the Law of the Sea at the Faculty of Law of the University of Lisbon and the bibliography annexed to this video article, and with great inspiration in the chapter by Professor Alan Boyle in the book edited by Johansson, Bush and Jacobson called The Law of the Sea and Climate Change, Solutions and Constraints, from Cambridge University Press, 2020. Environmental protection was one of the essential issues in the negotiations that led to the adoption of the United Nations Convention of the Law of the Sea in 1982. Other major concerns, such as the exploitation or control of offshore natural resources and the development of deep seabed exploitation, had their own significance, for sure, but also were seen as an ensemble, together with environmental protection. Environmental protection has also been at the core purposes of the International Maritime Organization, created in 1958, in the context of marine pollution from ships, and reached a peak with the International Convention for the Prevention of Pollution from Ships, 1973, as modified by Protocol of 1978 relating thereto. I'm speaking about MARPOL 73-78. Thus, environmental protection is a cross-cutting concern throughout the extensive articulate of the United Nations Convention of the Law of the Sea, and is present in many different sets of regulation therein, from innocent passage, Article 19, to scientific research, in Part 13, Articles 2, 3, 8, and following. Article 1, about the use of terms and scope, actually provides for a concept of pollution of the marine environment for the purposes of the Convention. It means the introduction by men, directly or indirectly, of substances or energy into the marine environment, including estuaries, which results or is likely to result in such deleterious effects as harm to living resources and marine life, hazardous to human health, hindrance to marine activities, including fishing and other legitimate uses of the sea, impairment of quality for use of seawater, and reduction of amenities. But the United Nations Convention of the Law of the Sea also has an entire part, Part 12, dedicated to the protection and preservation of the marine environment, Articles 192 and following. It regulates many aspects concerning states' obligations and distinguishes between pollution from land-based sources, from seabed activities subject to national jurisdiction, from activities in the area, pollution by dumping, which is conceptualized also in Article 1, pollution from vessels, pollution from or through the atmosphere. According to Article 192, states have an obligation to protect and preserve the marine environment, and this clearly shows a paradigm shift from a law focused on the uses of the oceans to a law focused on the protection of the oceans. To fulfill this general obligation, according to Article 194, Paragraph 1, states shall take individually or jointly as appropriate all measures consistent with this convention that are necessary to prevent, reduce, and control pollution of the marine environment from any source, using for this purpose the best practicable means at their disposal and in accordance with their capabilities, and they shall endeavor to harmonize their policies in this connection. And, in this sense, the measures taken pursuant to this part shall deal with all sources of pollution of the marine environment. So goes Article 194, Paragraph 3. The essential characterization of these states' obligations is due diligence and cooperation. Article 197 is an essential provision in this matter. States shall cooperate on a global basis and, as appropriate, on a regional basis, directly or through competent international organizations, in formulating and elaborating international rules, standards, and recommended practices and procedures consistent with this convention for the protection and preservation of the marine environment, taking into account characteristic regional features. Now, the United Nations Convention of the Sea does not address the problem of climate change. We must bear in mind that the negotiations that led to the adoption of the United Nations Convention in the Third United Nations Conference began formally in 1973, and the adoption occurred in 1982. But this does not mean that the Convention is irrelevant regarding climate change. In fact, the need for an evolving interpretation of its rules, on the one hand, and its relationships with other and more recent legal instruments point in the opposite direction, that is, of the Convention as an important legal piece regarding climate change. The Convention is also marked by a global bent regarding pollution, namely that from land-based sources, but not only, and this is mentioned by other international documents like the Agenda 21 of the 1992 Rio Conference report. As is well known, ocean acidification and warming have a consequential relationship with the absorption of carbon dioxide by oceanic water, which are issues at the core concerns underlying the 2015 Paris Agreement, as was before with the Kyoto Protocol. Now, though the United Nations Convention does not force states to cope and adapt to climate change, this does not necessarily mean that states' obligations therein should not be interpreted in an evolving way, such as to regard climate change. The oceans absorb around 90% of the heat created by global warming, and the ocean surface around 25% of the carbon dioxide released to the atmosphere. This cannot be overlooked when interpreting states' obligations in the light of Articles 192 and 194, paragraph 1, as to the meaning of all measures consistent with this convention that are necessary to prevent, reduce, and control pollution of the marine environment from any source. In this sense, land-based emissions of carbon dioxide, coming from factories and other structures which inevitably affect the oceans, as well as emissions from ships and aircrafts, might be considered to be covered by the state's obligations arising from these articles, and also 207, land-based pollution, and 212, pollution from or through the atmosphere. These obligations affect only states, not private parties, but the former must take measures to reduce marine pollution of those sources. Moreover, the fulfillment of states' obligations regarding, for instance, land-based pollution and pollution from or through the atmosphere must be met taking into account internationally agreed rules, standards, and recommended practices and procedures. The 2015 Paris Agreement is an important piece of that, as it sets agreed rules, standards, and recommended practices and procedures, especially for states that accept both the United Nations Convention and the Paris Agreement. This influence of one international instrument over the interpretation of another should also be assessed in the light of the principle of good faith in the interpretation of treaties and implementation of international obligations. What exactly does this relationship between international legal instruments require from states is something that cannot be addressed here. But it is a valid hypothesis that the United Nations Convention of the Law of the Sea leverages the implementation of rules and standards within other instruments that have the same function vis-à-vis the environment. The United Nations Convention works with a notion of due diligence that opens itself to be filled by other legal contributions, as it appeals to other rules, standards, and practices that states abide by. Another point of interest is the potential use of the mechanisms for compulsory dispute settlement in Part 15 of the Convention for environmental or climate disputes, as other instruments that deal directly with climate change do not have a set of dispute settlement mechanisms of their own. As there are good legal arguments for that, let's assume that climate disputes are covered by Part 15 of the Convention. Considering that the implementation of the said rules of the Convention depends on other rules, standards, and practices, that is, states' due diligence depends on them, Part 15 of the United Nations Convention of the Law of the Sea might be used for disputes, for that as they present themselves as United Nations Convention disputes, after all. In practical terms, some states might not be willing to confront others in this way, but it seems possible. And in legal terms, a state does not need to demonstrate a specific damage as an interest deriving from the collective interest of being part to the same convention should be enough for standing. This means, as Alan Boyle points out, that any state party to the United Nations Convention can bring proceedings for non-compliance with Part 12, irrespective of its own specific situation or damage. Any kind of compensation for damage would require, in any case, proof and consideration of the losses. The border activities case between Costa Rica and Nicaragua in 2018 in the International Court of Justice is an important case regarding this. But, in any circumstance, if the situation is the non-adoption of measures under the Paris Agreement that would be claimed by the United Nations Convention of the Law of the Sea under Part 12, there's a good chance that a court could determine that those measures should be taken. And if they are not, injured states might claim compensation. Many technical aspects are being left aside in this hypothesis, namely of procedural nature, for it is not possible to deepen that discussion here. But the possibility envisaged is that the United Nations Convention of the Law of the Sea can leverage states' obligations under other agreements related to climate change when they are essential for its own application, and can also lend its compulsory dispute system mechanisms as ancillary. From another perspective, this is compatible with the United Nations Convention constitutional role, as it shows both its constant adaptation and parametric role governing the oceans and securing their place in the global context.